Fernando Colon asked me to give you a lecture today on immigration remedies, and basically what I was doing is referring you to the EOIR or EOR's website, and there's your, I guess your address. It's www.usdoj.gov/EOIR/. Okay, EOIR actually stands for the Executive Office for Immigration Review, and I refer you all to this website. One, because not only is it the government's website, but it has a wealth of information on it. And as long as you are on the internet, you might not have to. I don't know if you are Westlaw or Lexis, but you might not have to pay your $5 or $10 grand, whatever it is, for your library once you come out of law school, because it's all on this website. Okay, and it's all for free once you have your internet connection. Okay. Now for remedies, there's only one thing I guess I'm going to presume as far as remedies is concerned, is that the government has already carried their burden of proof. Okay, so either one, on the notice to appear has been issued at the master calendar hearing, which is what we refer to as an arraignment. The government has already carried their burden of proof. Okay, so after the government has carried their burden of proof, I guess the question becomes is there any immigration remedies, or is there any immigration relief? Now, if you're going to be representing clients, basically that's going to be naturally what Joel's question is there any relief from removal? Now, if you look at INA Section 240C4, real quickly, and basically it's the burden on the alien. Now, after the Immigration Service has met their burden, there's a burden on the alien. And it's the alien's burden to establish that the alien satisfies the applicable eligibility requirements. Now, this is statutory law. So, if you're an alien seeking relief from being deported or seeking deportation, one, naturally you have to meet the statutes. So you're going to have to meet the law. Okay? But interesting enough, there's also a second provision in there, and it basically says, with respect to any form of relief that is granted in exercise of discretion, just about all forms of relief are in exercise of discretion, then the alien has to prove that he merits a favorable exercise of discretion. Okay? So one, when you're seeking immigration relief, not only do you have to establish that your client meets the statutory requirements, because even if you meet the statutory requirements, it doesn't mean the judge is going to grant it. Just because you meet the law, it doesn't mean the judge will grant it. Basically, the second provision in the statute says that the alien has to prove that he is entitled to this particular type of discretion. Okay? So, yes, sir?
It says 240C.
It's INA Section 240, and it's a little c, and it's number 4. If you use the vendors, I'm in the 2008 version. It's on page 481. 481.
It's capital A, isn't it? 240 capital A.
No, it's 240 little c, number 4. And it's the alien's burden of relief. So once again, the government's met their burden of proof. It's your turn on remedies. So the government met their burden of proof. What you need to prove is, one, that you're statutorily eligible, first off, and just because you're statutorily eligible doesn't mean the judge is going to grant it. You have to, second of all, show the judge that your client merits the discretion.
Is it beyond doubt?
I usually think it's usually beyond doubt.
Yeah, it is. Beyond doubt.
Okay. It's a pretty high burden. Okay. So, what are the forms of relief? Okay. So first of all, it's your burden of proof now. What are the forms of relief? Well, there's a slew of different forms of relief, and I'm just going to read them all out to you. And there's just no way we're going to be able to hit them all within an hour. But one form of relief, and I really do, I hate saying this one, but it's voluntary departure. I don't consider voluntary departure a form of relief, but technically the law and everyone considers it to be a form of relief. Voluntary departure is just simply that the alien is allowed to basically leave voluntarily. Now, in my opinion, usually when an alien leaves voluntarily, I don't want to say you necessarily self-deported yourself, but basically I think you've lost. Okay, but voluntary departure is technically a form of relief. Adjustment of status. We refer to adjustment of status going from a non-immigrant classification to a permanent immigrant classification. So adjustment of status is considered to be a form of relief. Asylum or withholding of removal. This is where an alien is fearful or scared to return to the country of nationality. Waivers of removal, and I'm going to show you all the different types of waivers of removal. Usually, let's see, non-protunct permission to reapply after removal. Non-protunct is like is a term we refer to as a relating back. So basically, maybe you weren't entitled to it at one point, but then later down the line you should have been granted, so we're going to relate it back. So non-protunct permission to reapply. Estoppel is a form of relief from removal. Estoppel in that you might be able to collaterally attack your previous order of deportation. An alien might be trying to be deported a second time. So maybe you can collaterally attack the first order of removal. Deferred action is basically we're going to, something dilatory, we're going to suspend the removal order and push it off to some other point in time in the future. That'll allow the alien to stay. Let's see, you understand what, okay. Waivers of inadmissibility. There's a slew of waivers of inadmissibility. I'm going to show you all those. Private legislation. You can actually pass certain congressional bills. Now, a lot of you say, okay, if you have the right connections, of course, you've got to get Congress to pass a special bill and the President to sign off on that. That's a form of relief. You also have what's called cancellation of removal, which is a form of relief, too. Now, research. How do you figure out all this? Well, that's why I'm pointing you, first of all, to this particular website. The EOIR's website, statistics and publications, I think, which is very important, as well as the virtual law library. So as I was telling you earlier, is that once y'all are out, hopefully y'all won't be poor first-year lawyers. You can't afford Westlaw, can't afford Lexis. Basically, I'd go to this website here. Now, can you click on that virtual law library for me?
Can you tell us what the website is?
Yeah, we put that up there already, but it's www.usdoj.gov/EOIR.
Say it again slowly, sir.
www.usdoj, U.S. Department of Justice, .gov, government, and it's EOIR, Executive Office for Immigration Review, not the A.L. Milne character, the donkey, okay? So you look at the virtual law library, there's a lot of information on here. It's a wealth of information. You have all the Board of Immigration Appeals decisions. You have all of your regulations here, plus all the legislation. They also have all the disciplined practitioners on here, so there's a slew of those. So if you do immigration law, I don't want you to just dabble. You need to do it right, because this is one area of the law where not only a lot of attorneys getting into it, but a lot of attorneys are being disciplined for it. Okay? And you can go on and on. Practice manual, I think, is very important. If y'all are trying to write motions and briefs or things like that, hit the practice manual, and it's going to give you all your forms. They're already been done for you. You just need to cut and paste. Okay? What I do want you to go to is, see that head note chart? Bring it down. See it says inner decisions and head note chart? Click on that head note chart right there. Okay, now bring that down. List of topics. Now what I just did was I gave you a list of a bunch of potential forms of relief or potential forms of remedy, and basically, if we go to the very top, we would mention adjustment of status as one of the forms of relief. Click on that adjustment of status. What do we get? We get all the cases, and this is a head note chart, right? So you're going to get all the cases from the government's website as to that particular form of relief. Okay, let's see, let's go back. And we could just, you want to go through it really slowly. You can go through the different topics: admission, entry, non-protunct. This is the permission to reapply. This is a form of relief that I had explained to you as well. Who is and who is not an aggravated felony. These are all the cases that the board is, of course this is necessary relief. I guess maybe you can say I'm not an aggravated felony, so we want to terminate the proceedings. But this is who is and who is not an aggravated felony. You can bring them down real slowly. Appeals, asylum, we identified as a form of relief, and basically it goes into all the individual topics. And if you can click on any of these, just pick one if you want. Basically, these are the cases that the Board of Immigration Appeals has decided. Yes, ma'am.
What is the airline fines head note?
Well, the airline fines head note is just basically that a airline, for example, let's say some of them fly internationally, and if they actually fly an alien into the United States and the alien is not admitted into the United States, then the airline can be fined for bringing the person here. And then basically there's Board of Immigration Appeals cases where the airlines has actually challenged their fines of bringing in individuals in, and maybe they've won or whatever. But there's statutory requirements for all that as well. And then we talked about cancellation or removal as a lawful permanent resident. That's one form of relief. You have cancellation or removal as a non-lawful permanent resident. That's another form of relief. And then you can just bring that down. Convention Against Torture, that's a form of relief as well. What is and what is not a criminal conviction? Detention and bond, we talked about the last time I was here. Let's see, we can bring them down. Here's all your motions. These, let's see, what we really want to get into, I guess, is waivers. Okay, let's go up a little bit. You got it right here. Section 209C waivers. These are all different forms of relief. 212C waivers, 212H waivers, 212I, Section 213. These are all remedies, right? These are all forms of relief. And if you want to, you can pick one. You can click on any of them. Section 213 waivers. And basically, if you look at the statute, Section 213, and you go into here, here's the government's website, and the government's website is actually giving you cases. Here's the case law, here's the head notes. And you can click on these, and basically you can read the individual statute on how to obtain a waiver, or to actually give you some type of guide or plan. Maybe you're the architect here. You have a client, I need some type of strategy, or I need a blueprint on how I'm going to obtain relief for my client. Okay? Well, this is the development of the blueprint for your remedies to allow your client to stay. And these are, if you're seeking suspension of deportation, which is a form of a remedy, okay, I want my deportation case suspended. Here are all the different case law. Now, what I should caution you on this as well is that, this is a wealth of information. This is great. And I think this is a good starting place for y'all. If y'all are going to be doing your architect or trying to come up with your blueprint for your strategy to allow your client to stay. Okay? But the qualification is that on these head note charts, the Board of Immigration Appeals started doing this in 1995. So all the cases from 1995 to the present, 95 through 2008, is on here. But there's also some older cases pre-1995 which they haven't gotten to yet.
Professor, let me make a point. You see a case there, matter of, I can't read it.
OJO?
Versus Lynn?
Oh, Cow and Lynn?
Yeah, that's under suspension of deportation, correct?
Right.
And it's in the year 2001. Suspension of deportation, like I told you, was incorporated into cancellation of removal in 1996.
Right.
So even though that case is 2001, what it means is probably that the events took place before 1996.
Right.
Because suspension of deportation doesn't exist anymore.
Right. So you understand that as well as that, as Professor Colon pointed out, that this act or this amendment to the Immigration Act, which is what we're using right now, this was passed or went into effect April 1 of '97. Now, it's possible that you have individuals that were placed in removal proceedings or deportation proceedings prior to April 1 of 97. And then maybe following their appeals procedures, maybe they lost and they go into the Board of Immigration Appeals, which is appellate procedure, or maybe they go into, I guess, what I like to call the real courts, or maybe to the circuit courts of appeals, and you're moving from the administrative courts onto the actual federal judiciary. The cases take time. So as Professor Colon's pointing out, 2001, 1996, you say, okay, maybe 5 years later. Well, appeals process can still take more than 5 years. Okay, but I think this is great for y'all to be referring to. Here's voluntary departure, which I reluctantly call a remedy or a form of relief as well, and withholding of removal. Okay.
Again, withholding of removal was pre-1996. That's incorporated. We only do in cancellation, voluntary departure, and then the waivers 212I, G, I, H.
Okay. Well, if you want to go back, let's point to say 212C, or actually let's do this. Can you go out of this page right here? Let's go out of here, and then let's go to interim decisions, which is next to the head note chart. And here are all the volumes of cases. Okay, so like once again, you don't have Westlaw, Lexis, go straight to here. Okay, you go find your head notes, you can find your cases real easily. Let's go to volume 16. Click on volume 16, and I think it's 2666. Interim decision number 2666. It's a 1978 case, which I'm looking for, and it's called Matter of Marin, M-A-R-I-N. Now, as we were discussing, is that you need to show discretion, or you need to prove to the judge that your client is eligible for discretion. Why is he discretionally eligible? Why, as a judge, should I like your client? To put it bluntly. Okay, I met the statutory requirements, but why, as a judge, should I like your client? Or why, as a judge, why does your client merit my discretion? Why does your client merit my mercy? Or why does your client merit my grace? Okay? Well, this is one of the big cases, or the cases that everyone should be familiar with. Did y'all go over Marin yet?
No, but I told them that it's a matter of balancing.
Okay.
We don't go into that case is not in the book, but it's balancing. That's what it says.
Okay. Basically, what Matter of Marin is that as far as discretion is concerned, as Professor Colon is telling you, this is a balancing act. Okay. What we want to do is we want to weigh the positive factors against the negative factors. And if it's naturally more positive, then basically the judge should grant discretion. If it's more negative, then maybe the judge, you follow the other side. Maybe the judge shouldn't grant discretion. And I think if you bring it down, let's get into the case. They actually start talking about the positive and negative factors. It's the very bottom of the page. I've read it so many times. Let's see. Let's bring it back. Bring it back, bring it down, bring it down, bring it down. Keep bringing it down. Let's see, bring it down some more. Maybe it's the next page, let's see. Okay, here you go. Okay, among the factors deemed adverse to your client, so these are the negative factors. Okay, why is it negative? Did you find that one? Right here. Among the factors deemed adverse to response application be the nature and underlying circumstances of the grounded issue, presence of significant violations, recency, seriousness. That's all the negative stuff. And naturally, we're going to let the government attorney harp on that. But of course, you know, this is negative stuff against you, so maybe you want to touch on it a little bit first. Let's see, bring it back down. Bring it down. Okay, evidence of support if favorable. Okay, there you go. Very bottom of the page. Favorable considerations have been found to include such factors as family ties in the United States, residence of a long duration, particularly when the inception of residence occurred while the respondent was a young age. So one of the positive things the court is basically saying is that if your individual has strong family ties in the United States. Okay? Another one is a long residence in the United States. So the longer you've been here, the more positive it's going to be. If you came in at a very young age, maybe some individuals are coming to the United States when they're 2 or 3, 6 months, who knows? Maybe even 18 could be a very young age. Actually, I tried to convince a judge. A woman got married to a U.S. citizen overseas. She came in at 18 and she was still very young when she was 18. Maybe it worked. Evidence of hardship to the respondent and family if the deportation occurs. Service in this country's armed forces. History of employment. Existence of property and business ties. Evidence of value and service to the community. Proof of genuine rehabilitation if a criminal record exists. In any other evidence. These are all positive things for your client. So when we're going to balance positive versus negative, how do I get the judge to like my client? Well, definitely we're going to be hitting on these things. Okay? As far as revenues. Let's see, if you want, you can go back. You want to go back up and maybe you can split the page a little bit. No, maybe we can't. Okay, that's just on the previous page, I think the top one's just the residence of a long duration and family ties. If anyone's trying to write those down, maybe we can just bring it down a little bit more. Does everyone have those? Anyone copying those down? Y'all have those? Okay, let's get out of here then. If anyone else is looking at this. Let's go back to the head notes again. That head note chart. And then let's go down to cancellation of removal.
But what if there's a lack of rehabilitation? Is that a negative factor or a positive factor?
It could be, you want to talk about this for 2 hours?
There's a case called Matter of Edwards.
There's a case called Matter of Edwards.
So you can find it over there.
Okay, let's go to rehabilitation. Someone is famous for Matter of Edwards in this room, and it's not me. The gentleman back there, should give him a hand. Let's see if we can go down to rehabilitation. Let's see if they... Rehabilitation? No. Go to 212C rehabilitation. Go to cancellation or removal. As lawful permanent residence, let's click on that. And then let's bring it down some under convictions. Bring it down some. Let's see. Bring it down some more. See if we can find Matter of Edwards.
Goes alphabetically. You don't have to.
It's important too. Okay, let's go back up to cancellation then. Yes, sir.
I think there's something when if Javier is looking for Edwards, you can do Control F and type in the word Edward, and I'm sure it should come up.
Try that and see if Edwards will come up.
Control F.
Maybe not. E-E-D-W-A-R-D. Right.
There's an S in that, I think. It's okay, let's move on. It's because he made me famous.
But basically, what Professor Colon did in matter of Edwards.
I wrote you out.
And basically what the government did in matter of Edwards is that they were trying to convince the judge that the client had to prove rehabilitation first. Prove that the client was rehabilitated before you got into the balancing act of a positive and a negative. Okay?
In other words, the judge found out that lack of rehabilitation was a negative factor.
Right,
Maureen says rehabilitation is a positive factor.
right.
So they twisted it around. If it's positive, lack of it is negative. And we argued it's not. And the Board of Immigration Appeals agreed. So they reversed that.
So you all following this? Okay.
Presence of rehabilitation is a positive factor. Lack of it is not
A negative.
a negative factor.
Right.
I just want to show my name in there so that they know that I did practice law before. They think I made it up, that I bought my license in Guanajuato. Go ahead.
And I actually, I don't have any published cases here at the Board of Immigration Appeals.
Not yet.
I have other cases, but not.
Well, it's not a good it did to me. I'm still poor, so it doesn't matter.
Me too, I'm still eating.
Yeah, it doesn't matter if they publish it or not.
Okay, so basically what we're talking about remedies. We were looking at the statutory factors of, here's all different types of relief for removal or remedies. And basically I jumped from there into the discretion. Okay? And I'm showing you all the positive versus negative factors. But what Professor Colon is basically telling me is one of the forms of relief that he wanted me to hit on is cancellation of removal. Okay? So, I don't have one of those cases, but I brought my law review article.
Okay.
I just wrote my law review article. It's,
You're a very humble man. You don't have my case, but you have your law review article.
it appears in University of Memphis's law review.
They have it in their webpage. They
Okay.
put it in there.
And what I'm going to do is I'm going to start off with just giving you a little history, just real quickly. There's a form of relief called 212C, which is the precursor to modern-day cancellation. And 212C is a waiver of inadmissibility. So if you're outside the country, you can't get in, it's a waiver of inadmissibility. And it's also a waiver that's available to individuals who are quote-unquote aggravated felons. Okay. And from 1917, when the waiver was first put into law, it stood in our law all the way until 1996 with this Immigration Act. And basically, this act repealed 212C as a form of relief. But following a Supreme Court case called Inez versus St. Cyr, basically the court said it was unfair to change the rules in the middle of the game, such that if an individual was eligible for the relief prior to the rules being changed, we're going to say that the individual is still eligible for relief. Okay? So cancellation, 212C precedes cancellation. Okay? But cancellation is what we're working with now. And cancellation basically, as some individual would say, was substituted for 212C. Okay? I just wanted to give you a history. Some of your clients could be eligible for 212C still. Okay? Now, if you look at cancellation, at the statute under INA 240, large A, little a, which is cancellation of removal for a permanent resident alien. What I also want to point out to you is that there's also a INA 240, large A, little b, which is cancellation of removal for non-permanent residents. So we have two types of cancellation of removal. One cancellation is for those who are already permanent resident aliens, and the other form of cancellation of removal is for those individuals who are not permanent resident aliens. Now, what I also want to point out to you is that because of the strict requirements of cancellation for a permanent resident alien, you could also have situations where your client might be a permanent resident alien and might not qualify for the statutory requirements for cancellation as a PR, but he might meet the cancellation requirements as a non-PR. If your client meets the requirements for a non-PR, then you can apply for eligibility for non-PR. Got that? So if you're not a PR, a permanent resident, then you'd be looking at 240 large A little b. If you are a permanent resident, I would look at both, cancellation for PRs and non-PRs, because your client might qualify under one or the other, or even both. Okay. Now, as far as 240 large A is concerned, which is cancellation or removal for PR, and this is probably one of the more common forms of relief that you're going to see in the immigration court today, which is a 240 large A little a. And the statutory requirements are just real simple. The first one says that the alien is lawfully admitted for permanent residence for not less than 5 years. The second one says that the alien is residing in the United States continuously for 7 years after having been admitted in any status. And 3 is not been convicted of any aggravated felonies. Now, 212C, as I pointed out to you earlier, which is the precursor for modern day cancellation, if you're an aggravated felon, you could qualify for 212C. But what modern day cancellation did was they knocked out that aggravated felony provision. So if you're not an aggravated, if you are an aggravated felon, you can't qualify for cancellation of removal as a PR. Okay. Now, we also have what's called the stop time gap rule, which is what I also want to point out to you, is that under the first provision, the alien has to be a PR for 5 years. Under the second provision, you have to reside in the United States for 7 years. Okay. What the stop time gap rule does is that it actually interrupts time. Now, that's found at 240 large A little d2. And what it simply says is this, is that if time is going to stop at the earlier of the issuance of the notice to appear or a criminal offense. So to give you an example, say you have alien who obtained their permanent residency, and you know for cancellation they need to have the permanent residency for 5 years. Or you also know that they need to be continuously residing in the United States for 7 years. Now, what will stop time or interrupt time is that if your client was placed in removal proceedings, or if they committed a criminal offense, basically that'll stop time or interrupt time. So to give you an example, this is what, October of 2008. If your client was convicted today of a criminal offense, or if your client was placed in removal proceedings today, what we want to do is we want to go back 5 years. And if your client was not a permanent resident within the last 5 years, your time may have been interrupted, so maybe we have to go back a little bit further than 5 years. Because we want to say from, I don't know, 2002 to present, your client has the requisite 5 years, right? Because today's 2008 October, and what's going to happen is that placing you in removal proceedings, or if you committed an offense, not a conviction, if you committed an offense, then basically that's going to stop your time from running for the 5 years and the 7 years. So in my example today, we're going to stop time, so we're going to go back 5 years. So if you have an extra day, say 5 years and 1 day, you should be able to meet the first requirement, PR for 5 years. But if you go back 5 years and 1 day, we might not be able to meet the 7-year requirement for continuous residence. So maybe we need to go back a little bit further. And the question is, has your client been residing for the 7 years or 5 years? You got that one? Okay. Now, if we're going to switch over to 240 large A, little b, which is the cancellation of removal for a non-permanent resident. And as I pointed out to you, remember is that say your client's a permanent resident and your client doesn't qualify for cancellation as a PR. Maybe your client can't meet the 5-year period, or maybe your client can't meet the 7-year period. Well, if your client can't meet that, you can always try to qualify your client for cancellation as a non-permanent resident. Now, the big distinction is that for the non-permanent resident, you have to be in the United States for 10 years. And once again, you cannot be an aggravated felon, you can't have been convicted of certain offenses. And one of the difficulties in cancellation or removal as a non-permanent resident, and I want to point this out to you because this is another form of relief that's very, very common in the court proceedings. I'm looking for it because I'm going to give you the exact terminology. Your client needs to establish that removal will result in exceptional and extremely unusual hardship to the alien spouse, parent, or child who is a citizen of the United States or an alien lawfully admitted for permanent residence. Now, I'm reading that directly out of INA Section 240A, B 1, D. D is in dog. Okay. Now, if you remember, under cancellation as a permanent resident, you don't have this provision of law. Basically, as long as you meet the cancellation statutory requirements, then you go over to matter of marine, and basically we're going to do the balancing factors. Okay, maybe you can meet cancellation as a permanent resident. For this one, you have this harsh requirement that you need to establish that removal will result in exceptional and extremely unusual hardship to the alien spouse, parent, or child who is a citizen of the United States or an alien lawfully admitted for permanent residence. Now, if you remember back to Marin, basically, if you would show that hardship to oneself would qualify as a positive factor. But under this provision of law, it says that it doesn't mention hardship to oneself. So you have to prove that you have a qualifying relative, hardship to one of your relatives who's a U.S. citizen or permanent resident alien. And when I say hardship, you also need to qualify because the law says exceptional and extremely unusual hardship. So that should tell you that we're going to put that way up here. Exceptional and extremely unusual hardship, something that's going to be rare. Maybe this is something that individuals are going to be rarely qualified for.
Could you give us an example of one of your experience that didn't
Sure.
make it, that was sad,
Sure.
and one where you got it?
Sure. Okay, now, what I like to do is this, was it Atlas? Atlas was the Greek god with the world on his shoulders?
Yeah.
Y'all remember that? Or was it Hercules? It was Atlas, right? Atlas has got the globe, and he's standing like this. Okay? So what you need to do is this. It says, exceptional, extremely unusual hardship to the alien spouse. So the spouse is up like this, or the parent or child who's a citizen of the United States or a permanent resident alien, right? So the question is this: how much hardship can you put on top of the shoulders of the permanent resident spouse or qualifying relative, and how much can they hold up? Okay? Now I'll give you an example. This is a case I actually won. I had a Pakistani national who met the requirements, and the hard part I needed to meet was this exceptional and extremely unusual hardship. The Pakistani national had 2 children. One was a boy and one was a girl. Okay? And what I did was that I told the judge, I said, Judge, well look, he's got 2 U.S. citizen children, and the children are going to suffer exceptional and extremely unusual hardship because one, they're going to Pakistan. Okay, they're not going to Canada.
How old were the kids?
One was 11, and I think the other one was 6 at the time. The girl was 11, and the boy was 6. Okay, so first of all, you have this huge, I guess, swimming pool, I guess, so to speak, or huge pool of individuals that are in it who are being deported. So the question is that how do I take them out of this big, larger pool and put them into much smaller pools? So I said, well, Judge, my client is not being sent to Canada or Australia or Europe or the UK. My client, or at least the hardship to the 2 kids, they're going to a country they've never been before, Pakistan. Judge told me, well, that's not enough exceptional, extremely unusual hardship. Kids are being deported to Pakistan all the time, right? Or parents are. Okay. So then, basically, I told the judges, I made it a little bit smaller because you leave in the larger pool Canada and maybe more other countries of Western, I guess, countries here, moving a little bit tougher place, right? Pakistan. Okay. So then what I did was I told the judge, I said, well, Judge, these individuals are what we call muhajirs. Okay, muhajirs are individuals that are not really Pakistani, but they're actually from India. But when the lines were drawn to make India and Pakistan, they just got caught on the wrong side of the line. Okay, so I told the judge, look, Judge, they're muhajirs. Now, because they're muhajirs, basically they're more or less discriminated against. Because they're really Indian descent, but they're officially Pakistani, and the people that are really Pakistani don't necessarily like them. Okay? So I said, well, Judge, they're muhajirs. So these kids are going to go to Pakistan. The parents are going to get discriminated against muhajirs. They're going to be muhajirs too. Judge said, not enough. I said, okay, Judge, well, they're going to be sent to Pakistan, to a state in Pakistan called Sindh, S-I-N-D-H. Okay? Now, in Pakistan, you have Punjabis, who are the elite class, and you have Sindhis, who are the lesser class. So not only the muhajirs, but they're Sindhis, so they're going to be discriminated even more. Judge said, this is not enough. Okay? So then I go into the fact that, okay, Judge, not only the language, okay, what are the languages in Pakistan? Urdu. Okay, Urdu. You've heard of Urdu, which is one of the common languages, or at least I thought was a common language in Pakistan. But only 7% of the population speak Urdu, according to the U.S. government report. So I have kids whose parents are being deported. The kids got to go to Pakistan. They have to be muhajirs. They have to be Sindhis. They have to learn a language. Of course, the kids speak English because they're U.S. citizens. They have to learn a language which only 7% of the population speaks. Mr. Hugh, exceptional, extremely unusual hardship. Still not enough. Okay? Smaller pools. Okay? Judge, I have a boy and a girl. Well, what difference does it make? Well, the boy should be able to go to school. But maybe the girl's not entitled to go to school. Not enough. Take it a step further. They're Muslim, Islamic. The girl gets to go to the mosque in the United States. But in Pakistan, when we see all the pictures, females are worshiping outside the mosque. She can't go in and practice her religion. That's enough. Totality of circumstances, exceptional and extremely unusual hardship. How much junk, how much dirt can I put on top of this poor little girl that she's going to have to hold up such that she's exceptional and extremely unusual? 5 more minutes? I'll give you another case. Here in Houston, young boy, U.S. citizen, parents, Mexican. Father's the one that's being deported. The son, who's a U.S. citizen, needs a kidney transplant. The only one that qualifies for the kidney transplant, the donor, is the father. The immigration judge here in Houston, which I won't give you his name or her name, but she said that's not enough. The boy is going to die from a kidney transplant if he doesn't get this kidney transplant. It's not enough because it's not exceptional, extremely unusual. It's not rare enough. All right? Went up to the Board of Immigration Appeals on the appellate court. They upheld it. Here in Houston, the medical community down the street, they were in uproar, went to the press, etc., and they finally overturned it and said yes, that it was exceptional, extremely unusual, such that this kid was going to die if the father didn't give the kidney. So maybe they met the requirement. I'm flying through all this stuff. Do y'all have some questions? Are y'all okay? I'm sorry, I'm doing remedies. I'm chopping it all up.
If you want to come another day, we'll have you.
I don't know.
Thank you, Professor. Let's give him a hand. Thank you, Professor. I was interested in the